Welcome to Understanding the Law. I'm your host, Peter Lamont, and I'm a business and personal law attorney practicing in the state of New Jersey. I'm also the principal of the law offices of Peter J. Lamont. The firm has offices in New Jersey, New York, Colorado, Puerto Rico, and affiliated offices throughout the country. Understanding the Law is a weekly radio broadcast where we discuss a variety of legal topics that affect our listeners. Please note that this broadcast does not constitute legal advice and does not create an attorney-client relationship with any of our listeners. As always, we welcome calls from our listeners. If you want to discuss any of today's topics, or if you have a separate legal question or issue that you'd like to discuss, we encourage you to call into the switchboard at 347-855-8831. We typically try to get through as many calls as we can. Occasionally, we might not have time, and so we encourage you to follow up with an email, which will be given out at the end of the show so that your legal question can be answered. So today we have an interesting show. Today's topics are some relatively new areas that I think affect most of our listeners, both business listeners and personal individuals. The first topic that I want to raise is something that was recently brought up in the New Jersey State Superior Court, and it involves texting while driving. Now, everybody knows that, regardless of what state you're from, that texting while driving can be a very dangerous and deadly event. We've seen the television commercials, and we've seen all of the campaigns and the things that come home with our kids in school about the dangers of texting while you're operating a vehicle. And it's relatively clear. It's self-explanatory. If you are watching your cell phone and texting and trying to push the little buttons so that you can communicate with a friend, you're obviously distracted and you're not able to give 100% attention to the road. So that makes sense. I can understand, and I'm sure most of our listeners can understand, why texting while driving, while you are the operator of the vehicle, is a bad thing, a dangerous thing, and that there are legal consequences in most states if you are in fact caught texting while driving. Well, the issue that we're going to talk about today is relatively unique, and it's the first time that this issue has been raised in any of the courts across the country. And this issue involves liability when you are texting a driver of a vehicle. Now, you yourself are not in the vehicle. You're not operating the vehicle. You're home in your house, and you're texting your friend or mother or spouse while that person's operating a vehicle. And in the course of that text exchange, the driver of the vehicle is involved in an accident. And it could be a pedestrian accident or an accident with another vehicle. What is your responsibility as the texter, if any? Now, prior to this decision that I'm going to mention in a few minutes, I would have said to you, probably nothing. And I'm sure that most of the listeners agree that, if you're sitting home texting and the recipient of your text is driving a vehicle and they get into an accident, how is that your fault or your responsibility? And how can any liability be attributed to you, the texter? Well, the Superior Court in New Jersey had a case that went up through the appellate division. And the appellate division, in discussing this particular case, which it's not exactly on point, but the appellate division references this idea that if a texter who is not operating a vehicle knowingly texts someone who is driving or operating a vehicle, and that person gets into an accident, that the texter is partially or can be partially liable for damages. Now, what's the important point here? The word knowingly. The appellate division specifically stated that there must be knowledge. So there's got to be some sort of intent. It's either knowledge, you should have known because you were aware. Let me rephrase that. It's either that you have direct knowledge you knew the person was driving, or you should have known. So let me give you an example of how this would work. If your spouse gets into the car and drives away to go to the grocery store, and you're home and you text him or her and say, I forgot to ask you to pick up milk as well, and the person's in an accident, that would be knowingly. You knew that he or she was operating a vehicle at the time you sent the text. So that is knowing that somebody is operating a vehicle, sending a text. Now, what if you are texting to your friend who is driving home, or a parent to their child who's driving home from a party or a friend's house, and you are not aware at the time you send the text that the recipient is operating a vehicle? And they respond to you and they say, yes, I'm on my way home, I'm in the car now, or I'm driving, or something to that effect. Something that would indicate to a reasonable person that the recipient of the text is operating a vehicle. And you continue to engage that person in texts, and that person gets into an accident. Well, under this appellate division analysis, you could theoretically be held liable for damages and injuries sustained by the other person who was involved in the accident. Why? Not because you had specific knowledge, but because you should have known. So there's two distinctions here. Knowledge, direct knowledge that you know the person's in the vehicle, and the other way that liability could attach is if you should have known. If somebody says, yes, I'm getting in the car now, and you continue to text them, you should have known that they would be operating a vehicle, because all of the communication leading up to that, for a reasonable person, would have indicated that they were going to be operating a vehicle. Now, the case that this came out of is a case by the name of Kubert versus Best. In that case, the appellate division did not find that the texter had any knowledge of the fact that the recipient of the text was operating a vehicle. And it was kind of a side note that the appellate division touched on. Wasn't really the crux of the argument. It was just something that came up, and the appellate division is creating essentially new law here. So what does this mean for you? Well, not only should you not text while you're driving a vehicle, I mean, that's pretty clear. You need to be cognizant when you send a text to somebody, at least in the state of New Jersey, and I would imagine that this is going to, work its way through the country the way that it always does when a law like this is introduced. It's clearly in the public's best interest. When you're sending a text, you need to be aware of what the recipient is doing. Now, it creates an added burden for you. It absolutely does, and some might argue that it's not fair. But the reality is that under this analysis, you could be responsible for damages. So what does that mean? Well, that means if the person that you're texting, the recipient of the text, is involved in an accident and causes property damage to another vehicle, or worse, personal injuries arise out of the collision, when the case is tried or the case is arbitrated or even settlement negotiations, you, the texter, are going to be brought into this discussion, and there's going to be analysis. Did the texter know at the time that he or she sent the text that the recipient was operating a vehicle? And if the facts prove that you did, you could be apportioned liability, which would mean you would have to pay money damages, monetary damages, you or your insurance company. So it's an interesting development, and certainly something that we should be following. And everyone out there should just be aware of the potential danger if you knowingly send a text to someone who is operating a motor vehicle. Now, you might be wondering, well, how can somebody tell if I sent a text at the time of the accident? And believe it or not, it's fairly simple. In most lawsuits now, subpoenas, especially motor vehicle accidents, the opposing party or the plaintiff in the case will typically subpoena the records of the cell phone carrier if there's reason to believe that cell phone usage had any sort of involvement in the accident. And the cell phone providers are obligated under the law, pursuant to the subpoenas, to produce the records. And depending upon the company, you can see the timestamp of the text messages, to whom the message was sent and from whom. So it is, believe it or not, relatively easy to determine who actually sent the text message and what time. So again, this is something we're going to follow, and it's a developing issue, but you must be aware of it, because you could be sitting home sending a text message, and the next thing you know, you are named in a lawsuit, and the damages are extremely high, and now you've got some sort of monetary liability. You're going to have to hire an attorney. You're going to have to notify your insurance company. So be careful and understand that this is something that I would believe to be going to be moving rapidly throughout the country. So that's it's something to note, and something we're going to follow. Now, the next topic that I want to talk about is something that is relatively overlooked, and it's an interesting topic, and it deals with hiring a personal trainer. So summer's over and the fall is here, and most of the people that we've talked to, either clients that we represent who own gyms or health clubs, they've indicated that there's a bit of an upswing in membership and attendance at gyms, primarily because the weather is getting a little bit cooler and people are preparing for the upcoming holiday season, where there's no holds barred and there's lots of cookies and cake and alcohol. So they're, I guess, getting in shape now. That's a good strategy. But what I want to talk about is selecting a personal trainer and what legally is involved when you get injured at a gym, and the obligations of the personal trainer and the gym owner. So what's interesting here is that, for the most part, someone who signs up for membership at a gym will go in, there's a stock contract, oftentimes not read. The only issue that you're looking for are the payment terms, so you know how the payments are going to be processed. And over the course of your training, you are either approached by a personal trainer, or the gym has these services that they promote and offer, or you realize that you haven't been in a gym in a long time, or maybe this is your first time, and you want to make certain that what you're doing is safe. You want to make sure you're doing it the right way so that you don't get hurt. So you go to the gym management and you inquire, and they hook you up with a personal trainer. And you have your first session, and he or she'll take you through some exercises and set up an appointment for next week, and that's how it goes. That's the typical I've hired a personal trainer scenario. I've gone to a gym, they've hooked me up with a personal trainer, I met with him or her, I like them, and they're going to give me some exercises to do. Now, what happens when 2-3 weeks into the program, you get hurt? You rupture a tendon, you injure your ACL, you tear a muscle or a tendon. For the most part, you've got no recourse. At least that's what you think. Oh, I went to the gym and I've engaged in these activities at my own risk, and maybe I went too heavy with a weight, or maybe I went too intense with an exercise, and I've been injured. But you've hired a personal trainer, and that personal trainer has a duty to you to make sure that what he or she is asking you to do in the course of the exercise routines is appropriate for you. So something you need to know is that in the event you're injured while participating in activities at a gym under the guidance of a personal trainer, you may have a lawsuit against both the personal trainer and the gym.